John Jay said we should read and study the Constitution so we will recognize when our rights are being violated and be prepared to defend and assert them. Yet today I review yet another federal court case where the lack of knowledge, not only of the people but of the lawyers and judges, and what's leading to another infringement on our rights and another example that we have no clue how to defend and assert them. So we'll discuss that next on the Constitution Study. Today I'm reviewing the case Merriweather versus trustees of Shawnee State University. Now the case stems from an event that took place back in January 2018. Dr. Merriweather, a philosophy professor at Shawnee State University, refers to all of his students as either sir or ma'am, or by a title like Mr. or Miss in their last name. Now during a January class, Dr. Merriweather responded to a student's question with, "Yes, sir." After the class, the student approached Dr. Merriweather and demanded the professor refer to him with feminine titles and pronouns. Dr. Merriweather offered to call the student by only their first or last name, but university officials rejected the offer. Instead, the university charged Dr. Merriweather with effectively creating a hostile environment for the student, placed a warning in his personnel file, and threatened further corrective actions unless he articulated the university's ideological message. Now, this led the Alliance Defending Freedom to file suit on Dr. Merriweather's behalf in the U.S. District Court for the Southern District of Ohio. From the court's opinion, quote, "This case involves the complicated overlap of issues concerning transgender identity, civility in public discourse, academic freedom, and the First Amendment's right to free speech and free exercise of religion," close quote. Rarely have I read so much confusion and misinformation in a single sentence. Although coming from a federal court, I'm not really surprised. The only reason any court is dealing with a complicated overlap of issues is because they ignore the most basic tenet of rights. For a right to be legitimately exercised, it cannot infringe on the rights of another. I suppose when some people look at this case, they can see issues of identity, civility, and academic freedom, and the First Amendment, at least when they ignore the actual language of the amendment. Quote, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech." I don't know how many times I've said it, but apparently it needs repeating. The First Amendment specifically states, "Congress shall make no law." This infringement on Dr. Merriweather's rights was not instituted by Congress or by any agency acting under the authority of legislation created by Congress. So this cannot be an infringement on the First Amendment of the U.S. Constitution. This is, however, a violation of the Constitution of the State of Ohio, Article 1, Section 11. Quote, "Every citizen may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of the right, and no law shall be passed to restrain or abridge the liberty of speech or of the press." And the student has the right to request that Dr. Merriweather address him in the manner he wishes. But the student has no more right to force Dr. Merriweather to address him a certain way than Dr. Merriweather has the right to require the student identified by his actual sex. In fact, once the student began berating the professor, he abdicated his right to speak freely on the subject by violating the rights of another. Maybe if we all spent more time trying to protect the rights of others than trying to get our way, this whole event might not have happened in the first place.